So I would like to formally introduce Rupali Sharma. Rupali is a legal fellow from the Center for Reproductive Justice. She joined the center in 2014. She first worked at the center from 2012 to 2013 as a legal fellow in the Europe program, where she helped develop a case challenging a national abortion ban. Before rejoining the center, Rupali served as a law clerk to the Honorable Matthew F. Kennelly of the Northern District here in Chicago. She previously interned with the Supreme Court of India and was a summer associate at Skadden Arps. Prior to law school, she worked as a shelter advocate at Nagar, an organization serving recent immigrants and coping with domestic violence. Rupali holds a JD from Yale Law School, where she helped local residents secure asylum as a director for the Immigration Legal Services Clinic. She graduated magna cum laude and Phi Beta Kappa from Northwestern University with a bachelor's in political science and gender studies. She's also fluent in Hindi. We were also hoping to have with us today Stephanie Toti. She is the senior counsel, and she actually performed oral arguments in Whole Women's Health, which we'll be talking about today. Stephanie is busy jet-setting across the country. She was in Kansas, and they thought that flight would be really easy, but it wasn't, surprisingly. So she's trying to join us right now. Hopefully she'll be here. But I am going to let Rupali take it away, and maybe Stephanie will be here at a later date. So please join me in welcoming Rupali Sharma.
Hi, everyone. So thank you so much for being here. I know there are probably 100 things going on at the law school, and you have finals coming up and all of that. So I really, really appreciate it. For those of you who don't know, I'm from the Center for Reproductive Rights, and the Center for Reproductive Rights is a global organization. I thought I would just give you a little background so you know where we're coming from. You're probably more familiar with our US work, which basically involves challenging reproductive rights restrictions, usually abortion restrictions, because that's what legislatures tend to pass in mostly conservative states, because that's where the legislatures tend to pass those laws. And so we work a lot in Texas, obviously, but also Kansas, where Stephanie is coming from, Oklahoma, Arizona, those kinds of states. And so, yeah, not surprising. And that's really what our litigation work focuses on in the US. But I'd like to give a little background really quickly just on our international work too, because I think what makes us a little different from other reproductive rights organizations, including reproductive rights organizations that actually litigate, is that we have a human rights framework. And that's very much informed by our global work. And so we have offices in Nairobi, in Kathmandu, in Geneva, and in Bogota. And each of those offices advance reproductive rights in their regions in partnership with local organizations and individuals that have been the leader of those fights for years and years and years before we got involved. And they also use slightly different legal tools depending on the needs in those regions. So for instance, the first project I was involved at the center was in Tanzania, and we were working with local women's groups and also local education reform and children's rights groups to help decrease this practice of forcibly testing adolescent schoolgirls for pregnancy. And it was a very well-entrenched practice. And our focus, whereas in the US, I think we would just sort of go to state court and sue the local school board maybe and sue the state, there we really needed to generate evidence, and not in anticipation of litigation later on, but really to bring women and girls' voices to the forefront and build an informational base so that we could influence the local government there, and specifically the Ministry of Education, to change those practices. And so that's just to give you a sense of this work is done in vastly different ways depending on the context. In the US, what we face mostly is targeted regulation of abortion providers, known as trap laws. And abortion facilities have been dealing with trap laws, for ages, basically since Roe. But the last few years, and I would say really since 2009, we've seen an unprecedented number of them, and they've gotten increasingly more restrictive. And when I say that, I don't just mean harsher penalties or that health boards are less cooperative working with physicians or clinics. I mean that they're less sensitive to sort of how clinics actually work and what might be applicable to them. And that sort of mentality has led to clinics being unable to comply with the laws and to being shut down. And most of them involve things that aren't very sexy and things that you don't think of when you think of abortion restrictions. They're not, say, bans, right? They're not 12-week bans or 20-week bans. They're construction requirements. They're administrative administrative requirements. There are these really boring things that I think it's hard for the public to understand and care about and to really connect with the shutdown of abortion clinics throughout the country. And so in Whole Woman's Health v. Hellerstedt, the name has changed a couple of times, we have two provisions. And both of the provisions are actually part of HB 2, which was an omnibus abortion statute enacted in July 2013. And so the first provision forces abortion providers, every single provider in Texas actually, to have admitting privileges at a local hospital, even though privileges are often granted or denied for reasons other than competency, including economic reasons. So to illustrate, because the complication rate associated with abortion is so low, abortion providers are extremely unlikely to admit very many patients to the hospital. And if a patient did need to be admitted, they would go themselves. But in general, there aren't a lot of patients coming from abortion clinics into hospitals. And that means that abortion providers don't really generate a lot of revenue for the hospital. So the hospital doesn't have the same economic incentive it has maybe with just a practicing OBGYN who does surgeries at the hospital as well to grant those privileges. And so in that sense, privileges don't have anything to do with the caliber of care that the physician has been offering in the community for years, or their stellar medical credentials, where they did their residency, where they went to school, what other providers they've worked with. And so in that sense, it's not that the hospital hates abortion providers and is trying to shut down clinics, but the law was crafted in a way where it has nothing to do with the way abortion clinics and hospitals actually work. And so what happens in practice, the clinics shut down. And what we saw in Texas was when the admitting privileges requirement took effect in October 2013, literally half of the clinics in the state of Texas shut down, right? So we had over 40 before HB 2 was enacted, and that number plummeted to 20. In a state that's the second largest state in the country, has 5.4 million women of reproductive age. The second requirement that we challenged in Whole Woman's Health forces abortion facilities, some of which have been operating for 30 years in their communities, to comply with the criteria for ambulatory surgery centers, which we call ASCs. And ASCs typically involve surgeries that are more complex than even surgical abortion. And for that reason, they've always been subject to more onerous regulations. And again, the sort of regulations I was talking about earlier, like sort of boring things that you wouldn't associate with the abortion wars, right? Like how wide your hallway has to be, how high your ceiling has to be. So clinics have been operating very safely without those regulations and now are facing them. And I think maybe the clearest illustration of the mismatch, I think, between the regulations and like how abortion clinics actually operate and maybe the safety concerns women would actually have is the regulation that requires women who opt for a medication abortion. And for those of you who don't know, a medication abortion basically involves taking a series of pills, and oftentimes the second part of that administration is done at home. It requires them to take them in an ASC, which again is a multi-million-dollar facility, right? So there's no nexus between the safety in the medication abortion and how much money was put into constructing the facility and how high the ceiling is and how wide the hallways are. But having to do that and having to expend that money, which is anywhere from $1 to $3 million for each facility, shuts down the clinics because they don't have the money. And I think one crucial point is that a lot of these clinics are nonprofits themselves. Like, we're a nonprofit and we represent the clinics pro bono, but they themselves are often nonprofits, and they were founded, some of them shortly after Roe, to really serve a community of women who had been underserved, right? So if you look in the Rio Grande Valley, for example, that's a traditionally underserved community, and some of our clinics were founded to serve those women. And so when the ASC requirement, if the ASC requirement had taken effect, and as I'll tell you, it didn't actually take effect because we intervened, but if it took effect, along with the admitting privileges requirement, it would lead to the shutdown of over 75% of the state's clinics. So basically, we would be left with 10 or fewer throughout the entire state of Texas, leaving like very vast swaths of the state without a clinic. So we challenged the law in federal district court in August 2014. And we argued that each of the restrictions violates a woman's right to end a pregnancy pre-viability under the 14th Amendment. And I'll talk about the standard a little later, but first I wanted to focus on the factual findings that the district court made. One thing I think is interesting about this case, especially as compared with the previous big abortion rights cases that we've seen in the past, Casey and Gonzalez being, I think, the most well-known examples, is that Texas has consistently argued that these restrictions were meant to promote and protect women's health. Right? It's not that standard dichotomy of like, well, it's preservation of fetal life and potential life on one hand, and then it's the woman's autonomy and dignity and equality and whatever rights you might ascribe to her on the other. Right? That dichotomy is not in play in this case. Texas has never argued that this is a fetal life justified restriction. It's supposed to actually protect women and result in better health outcomes. And so we had a trial. We had 19 live witnesses, 12 of whom were experts. And it was Texas's job, we argued, to prove that these restrictions actually improve health in some way. Because you could imagine a place, right, even if there was only one abortion clinic in a state, if the doctors were unethical, if they were hurting women, we would want that clinic closed too, right? The fact that the restrictions were saving women's lives would outweigh the lack of access to abortion in that circumstance. And so we wanted Texas to show that either there was some problem or some enhanced health benefit that would outweigh the lack of access that the restrictions would have resulted in. And so the district court found that there wouldn't be any health benefit to either of the restrictions, that it wouldn't result in better care or it wouldn't result in better outcomes. And in fact, that the restrictions would actually jeopardize women's health by cutting off abortion access. And I think that first quote there was really the central factual finding. And I also think it's important to understand how the district court got from, well, over 75% of the clinics will be shut down to women's health will be jeopardized. What it did was it looked at how the restrictions would actually play out in actual women's lives in Texas, which aren't the same as communities of women in Kansas or in Oklahoma or Florida, right? Like every state is different, every community is different. And the district court actually looked at what the women in Texas, particularly the most vulnerable women in Texas, including in the Rio Grande Valley that I mentioned earlier, what they were going through. And so it saw that, yes, you know, when abortion clinics shut down, typically women have to drive longer and the waiting times increase, right? You only have like 10 clinics left. All the patients who would have gone to the other clinics are now going to those 10. But what did that mean for women who traditionally had a problem accessing health care in the first place, or are low income, or in Texas, you know, it doesn't have like a fantastic public transportation system. If you don't have a car, or you don't have access to a neighbor or a friend who will let you borrow their car, what was happening? And so it actually, in the opinion, identified these things, talked about like, look, well, women who are facing longer wait times, the expense of the abortion is going up. And how are they funding the abortion? Well, they're pawning personal belongings. There were stories of women pawning their wedding rings. They're going to loan sharks and just taking out a loan at a high interest rate. In some cases, you know, they're forced to make a decision between leaving their kids alone or finding care because they'll be gone longer than 2 or 3 hours. They'll be gone overnight. They're sleeping in their car because it's expensive affording a motel for 2 nights. So the district court looked at those things, those realistic things, and factored that into the analysis of whether the restrictions were actually promoting health, and found that it didn't. And so, you know, then the standard comes into play, right? So like the restrictions don't promote health at all. Why does that matter? And the standard, the reigning standard, and we haven't disputed this in this case, is the undue burden standard, right? You can't impose an obstacle on a woman that essentially eliminates her right to abortion. You can persuade her not to have an abortion, right? There's a distinction between coercion and persuasion, but you can't basically coerce her out of the choice. And we argue that the court should understand that to mean, as I said earlier, look, if a law is actually promoting a legitimate interest, and women's health is certainly a legitimate interest, and that promotion outweighs the burdens that the law is affecting on women, then that law is probably constitutional. But if the burdens are up here and there's little to no benefit, then the burden is undue to that extent. And so that's how we defined undue burden, and that's how we think Casey defined undue burden. And so that's just to say that this case, as much as it is about the facts behind these laws and the facts in Texas, is very much about the integrity of the standard and what does it have to mean for Casey to have meant anything. And as you will see, this is just a map essentially of the different circuits. We ourselves forget sometimes where the states are, but there's a pretty definitive split in authority, which is why we thought our cert petition would get granted. So the Fifth Circuit basically doesn't think it's appropriate to factor in the sort of concerns I discussed earlier, right? The whole, well, some women don't have the money to afford childcare, some women have to sleep in their cars, because it reasoned that that is not a burden that the law created, right? That burden has always existed. And so it's wrong to attribute that to the law and factor that into the analysis. If the law isn't causing women to not get abortions at all or to go through great lengths to get abortions, then it's constitutional, it passes muster. And so obviously that's very different from what the district court did. The second notable thing is that the Fifth Circuit didn't set aside the district court's factual findings. It didn't say that, it didn't impugn our experts. It didn't impugn the many organizations that stood up with us, including AMA and ACOG. It said that the district court was wrong to conduct that analysis, right? If you could rationally speculate that a law serves a health interest or serves another legitimate interest, that passes constitutional muster. And then again, if the burdens aren't essentially equivalent to preventing a large number of women from getting abortions in the first place, or significantly burdening them, not taking into account, again, poverty and all the other things that people deal with, then it passes constitutional muster. And so really, it came down to, what does the undue burden standard mean? And so the split lies in that, right? So the Fifth Circuit has interpreted that way. The Seventh Circuit and the Ninth Circuit has sort of adopted that balancing approach, right? If you could find a law that really served interests well and those interests were strong, even if the burdens were great, if it outweighed those burdens, it would be constitutional. But if the burdens are up here and the interest, either the legitimacy of the interest or the extent to which it's furthered is down here, then the law is unconstitutional. So we have a split there. So I'll go back a little bit to our timeline. Yeah. So after we won in the district court, obviously Texas appealed to the Fifth Circuit. But in between that, we had some drama at the Supreme Court, which again was one of the reasons why we felt confident filing a cert petition and really taking the case to the court to begin with. After we won at the district court, Texas asked the Fifth Circuit to stay the district court's judgment, and the Fifth Circuit agreed. And so we were in this very weird limbo for literally, let's say, like a week and a half, where our clients, our clinics, had made appointments for women for the following week and then had to cancel them because we had won the case, and we're like, yes, it's going to get appealed, and then we'll see what happens and we'll counsel our clients. But the decision got stayed. And so it was just surreal. It was literally like calling up women and saying, like, look, so the court put it on hold, but we're gonna ask the Supreme Court to change it, but we don't know what's gonna happen. So for now, cancel your appointments, but then call the women back. It was very, very strange. But luckily, when we asked the Supreme Court to vacate the stay that the Fifth Circuit had imposed on the district court's judgment, it agreed. And that, I think, was our first sign, like, one, the court's interested in this case, probably because of the litigation that's going on throughout the country and the uncertainty surrounding the undue burden standard, but two, it sees a burden here. It was willing to vacate that stay. So we felt hopeful at that point, and of course, practically, it was extremely important to the women of Texas because what the vacation of the stay did was, one, it kept the ASC requirement enjoined throughout all of Texas. So, which is why I said earlier, the ASC requirement never went into effect. The Supreme Court made sure that the district court's judgments was preserved, and so the ASC requirement is not in effect. The other thing it did was it allowed the district court's injunction of the admitting privileges requirement to stay in effect as applied to 2 clinics only. So it is in effect in the rest of the state except 2 clinics, which has, again, allowed us to sort of, I think, better document and witness the burdens that law imposes, even though it's obviously having a lot of negative effects on our clients. So then after the Fifth Circuit reversed the district court in large part, we knew that we would all be at the Supreme Court again. We asked, it's procedurally correct to ask the Fifth Circuit at that point to stay its own judgment, which is an odd situation to be in because they just ruled against you, and you're asking them to put their decision on hold until the Supreme Court reverses them. So, you know, even if we didn't have the sort of relationship that we do with the Fifth Circuit, which admittedly, and I think depressingly, given that courts should really shouldn't be political and this should be about standards, like, is hostile, right? Like, they typically rule against us and our issues. Even if you didn't have that, you had this very weird, I think, like, procedural wrinkle of, like, you're definitely wrong, and we want the court to say you're wrong, so can you just hold off right now? And they were like, hell no. So not surprising at all. So we went back to, you know, the Supreme Court, our new best friend, and we asked them essentially now to stay the Fifth Circuit's judgment, and basically made the same arguments we had made at the district court stage, right? Like, the same crisis that we had discussed earlier is still there, and it's only deepened because now some of the admitting privileges requirement is in effect, right? And the Supreme Court agreed, right? And so again, we felt like, oh my God, like, we can actually, like, take this case to them. They're interested and they see the burden, right? And so that was super exciting. So let's fast forward a little bit. So we filed our cert petition, and Stephanie, who hopefully will be able to make it, argued the case. So I'll hold off on that, and I'm happy to sort of give you a recounting of oral argument and how we think it went, and some of the funnier, odder things that happened there if she doesn't show up, but it would be better to hear it from her. But I do want to discuss, you know, now that the case is in front of the court and they're deciding it, and probably not remanding it, because if they wanted to remand it, they probably would have by now. Now we're really looking at what the impact of this decision is going to be and what the impact of a loss or win is going to be. And I think, you know, the clearest impact obviously is on this 5.4 million women in Texas, right? Abortion access in Texas, which clinics are going to stay open, which are going to close, what sort of situation are we going to have? Is it going to be somewhere in the middle? Is it going to be what we have now with the stays in place? We could lose completely, like, we just don't know, right? But that's definitely the first question. But I think there are some other important questions as well. So Texas-style restrictions, the admitting privileges requirements, and the ASC restrictions are fairly common. Texas definitely is the most draconian in the sense of it's shut down the most clinics. And to give you an example, you know, there are ASC requirements in 5 other states, but all of them allow waivers. So clinics can kind of like try to work with the department to comply with some of the regulations, and when it really can't, the department will say, okay, you tried, and we sort of get why you don't have to take pills in a multi-million-dollar facility, we'll waive that. Texas does not allow waivers categorically. It's not up to the health department. So in that sense, Texas is more draconian, but my point is that these restrictions are very common, and a loss would signal to not only these states, but states that are on the cusp of enacting the same restrictions that, hey, you have a blank check. You can enact abortion restrictions, and not just, you know, abortion restrictions as in like regulation of abortion practice, but restrictions meant to make it more difficult for women to access abortion on the pretext of women's health. You can do that. And so I think that's sort of the scariest thing, that larger effect that it would have on legislatures. The other thing that we're concerned about, obviously, and this is where all the trap litigation corresponding with those laws is happening by us and also Planned Parenthood and ACLU. The other thing we're concerned about, is just, you know, if we get a poor standard, right? You could see the court saying, like, look, Texas is in crisis. We totally got that. You know, we vacated your stay, and then we gave you a stay, and we get it. This situation is out of control. It was an emergency. But, you know, we don't understand how Oklahoma is similar. Oklahoma has more than one clinic, right? Mississippi has one clinic, but we promised not to shut it down. You know, like, you could see how it could sort of think of Texas as an outlier, give us relief, but maybe not clarify the standard, right? And so we're left with sort of the same dispute or murkiness that we had after Casey. Now, I personally don't think that's going to happen, because I think probably a large part of why the court took the case was that the litigation is getting out of hand, the restrictions are getting out of hand, right? It's not just that Whole Woman's Health is up there. A case in the Seventh Circuit is basically up there as the, you know, cert briefs are being filed. There's a case coming up from Alabama. There might be other cases, you know, in the woodwork, like at the district court level. And so, you know, I mean, they can swat us away, but they're going to have to decide that question. And I think it's very squarely presented in this case. And so that's why I think they will address the standard. That said, I don't think that it's a win for us unless they really take into account the evidence that a state has to present when they burden a fundamental right. And I say fundamental right because the third sort of impact that I think is really important is not just, as to women seeking abortion in Texas or women seeking abortion in other states, but really sort of the integrity of the law, right? Like, abortion is a fundamental right and definitely an especially contested one, I would say, right? But the idea that you could burden or in some places eliminate a fundamental right without basically showing evidence, I think is dangerous, right? We know this with like all areas of law. Nothing's Kavanaugh, right? Like, you cite a case and you're like, hey, they did that in that context. What makes this different? And so I think even if you don't care about abortion rights or you oppose them, I do think there's something interesting going on about the law here, and another worry we have in terms of how they'll decide. That said, and in part because of how oral argument went, we are fairly optimistic, and I'll put up some quotes from the judges. Well, first, here's Stephanie arguing the case, which I think is very cool. So, the quotes that we chose, and it was hard because a lot of them were like fairly theatrical. Like, I had never been to an oral argument, much less in my own case, right? And to me, it was like a really good show. Like the judges weren't sitting there and like spur of the moment, like the way an actress in a show does, and you're like, oh, she's so cool. Like, no, those lines were written for her, right? They write their own lines, but like it was clear that everyone came in there to play a part and had questions that they wanted to ask, and like also wanted to ask them in a way that like would get a rise out of the audience and certainly would get a rise out of the other justices, including Justice Kennedy. So, that to me was interesting, and I don't know what to make of it. But anyways, the quotes that we chose really sort of center on the standards. I think Justice Roberts, not surprisingly, wasn't very convinced by our argument about how Casey is read, and really sees undue burden as just burden, right? Like, basically what the Fifth Circuit says, that if you have a legitimate interest, you don't probe any further. How badly is abortion being impacted? How bad is it? Are women not getting abortions at all? Is it really, really hard for them? That's undue burden. That's where he was. Justice Breyer, again, like, it shouldn't break down on these lines, but it does, like, basically understood what we were saying and felt like, okay, it has two components, and that's what undue means. Same with Sonia Sotomayor. But, we put the quotes up because I think, like, the way they ask it and how many words they use and is just, like, interesting and, distinctive to their personalities. And Kennedy, which everyone was paying super close attention to, obviously, and he doesn't give much away, and like literally was like staring at his face the entire argument, and he was very measured, like as he has been, I think, in a lot of really, really closely watched arguments, including Obergefell, right? Like he asked hard questions of both sides, but not as many questions as anyone else, and really like sort of had a poker face. But this quote, I think, we found promising because we felt like he might not only get what we're saying about the standard, but believe it. And this is especially tricky, right, because Kennedy wrote part of Casey. He's the only justice left who wrote the part of Casey that we're citing. And so it's a tricky situation as a litigator to tell a judge, and I think litigators do this all the time, but it's all in how you do it. This is what you meant, right? Like these courts, they're taking your words and they're distorting them. This is what you meant. And you had to mean this because if you did mean this X, Y, and Z. Like Casey couldn't have protected a fundamental right to abortion and women's liberty and equality and all this gorgeous language that's in Casey and Texas be okay, right? Like I think if you wanted to boil down our like fancy legal arguments, that's it. And so I thought, as a very, very young attorney, in age, but also just in terms of experience and at my organization, I thought that was just like a very fine dance to learn how to do. And so hopefully we did it okay, but I think this quote suggests that he may believe that that's what he meant. Maybe that is what he meant, right? So there were some other issues raised. If anyone did listen to the arguments, you might have noticed that the first question was from Justice Ginsburg, and we're like, oh, here it is, right? She's like, isn't this case precluded? Or it was about res judicata, which is a procedural issue, and basically it says, this is not going to be very artful, but just to summarize it in 5 seconds, it basically says that if you brought a case earlier, or you brought a claim earlier, and the same parties are bringing another claim, it's the same claim, it's the same parties, it's precluded, which makes sense, right? We didn't think that was the case. They were referring to an earlier case called Abbott, and in Abbott we challenged the medication abortion prong of HB2, which basically bans a certain popular scientifically accepted method of medication abortion, and then we also challenged admitting privileges. But our argument was well, yes, we challenged admitting privileges, but you struck our arguments down because you said we didn't have evidence to show that admitting privileges were truly burdening women in Texas. And then they went into effect, and then we saw how they were burdening women in Texas. And so the key there is material operative facts, right? Those facts change, and that was our argument. But the fact that Justice Ginsburg raised it, and that's how the argument opened, and Stephanie had to spend, I would say, most of the allotted time addressing it until she was given more time by Chief Justice Roberts at Justice Ginsburg's urging, definitely made for some tense, a tense introduction. And that's to say also, those procedural issues are important. I personally am less worried about it because, one, I think we're right on the law. I firmly believe that. And two, I think it's the type of issue you deal with at the cert stage, right? If this case is precluded, don't grant cert. And you would know that. And so I feel a little better about that. And I think Stephanie dealt with it marvelously, but that's certainly how the argument started. And for a while, that's what we were talking about. So I wanted to make another point. So I was in court with Stephanie and the rest of the team. But while I was, there was a very robust movement going on outside, right? And it was from both people who support our litigation and support our organization and support our clients and the women we represent, and then people who vehemently oppose it. And I think in both camps, what was interesting was, and not surprising, was that people were very vocal, but it also was just the most diverse movement I've ever seen on both sides. Really, and I don't just mean diversity, racial diversity, but just all different kinds of people, ages and professions, and the way they understand reproductive rights, regardless of what side they stand on. And obviously, and given what I do and the mission I believe in, I was really happy to see our supporters and people standing up with our clients who I think go through a lot. I think it's good for them to see that people support them. But I think the greater point, and this is why I'm including people who oppose us as well, is that, part of the argument we're making in this case, and I think the Fifth Circuit rebuffed, was this idea of who does the law belong to, right? When we're talking about taking into account those factors that I talked about earlier, having to drive far, and all the things that are going on in Texas that we've documented for years in other contexts, why should the court do that? Should the law be that practical? Are judges equipped to do that? I think these are still open questions, and I think in the abortion context, we've taken a stance, and we're pushing judges to say, look, you can't look at these regulations in a vacuum. And I think having the arguments going on inside and having the litigators in there, but then just people who live and breathe this every day in a not law way, they're because they care about the law and understand what's going on and want to be in front of the court. I think that was important. And hopefully it sent a message. So, and I think I went over this basically, what would a win be? A win for us is not only restoring abortion access in Texas, but getting that standard. Getting a standard where if a state passes a law, it has to provide evidence as to the interest that it furthers and to the extent it furthers it, and then getting that balance, right? An abortion regulation can absolutely be constitutional as long as the burdens don't outweigh the promotion of the interest. So that's all I have. I can take questions now if that's okay. And again, we can wait around for Stephanie, and then if not, I'm happy to answer any other questions about oral argument on her behalf, I guess. Yeah.
I think we should start by thanking Rupali for answering. Start us off with
Mhm.
I remember getting a text message in the fall that their cert had been granted, and just thinking, oh no, it's early, and it's, the bench was different at that time, and I was very nervous. And I'm wondering if you can give us a little insight about, some of it is that you really didn't have a whole lot of a choice, right? There were some extreme things going on, and you have to represent your clients. At the same time, I'm just wondering if there are any strategy sessions or conversations at the center about like whether or not this was a good time.
Yeah, we're not typically, so it was funny, right? Because when we started drafting the cert petition, we're like, well, let's pull up our last cert petition. And no one knew when we had last filed a cert petition, right? Like, we have tons of op certs. Like, we write tons of op certs, right? But we traditionally are not storming the court and asking them to take our cases, at least in the last 10 years or so, for the reasons you're saying. But I think, you identified it in your question. One is that, you have clients and you don't really have a choice. If they're out of options, if we would have been left with 10 clinics, what are we gonna do, right? Like, we had to challenge the restrictions. Like, to some extent, and I hate to say that because like strategy goes out the window in terms of just whether you bring the case at all, we had to challenge it. That said, I do think that there is a value, the undue burden standard in KC is the reigning standard. And again, Kennedy pretty much authored that standard, or at least is the only justice left on the court that authored part of that standard. So I think if we're gonna advance the ball at all, and again, putting aside like who the next justice will be, we have to articulate a really sophisticated, accurate argument about why we win under that standard, and not only in Texas but in other states. And so if you read our briefs, you would see that we really try not to make this continually about like all the clinics are shutting down, because we can't win in a world where all the clinics have to shut down for the undue burden standard to apply, right? Like, that's not going to be the case in most states, but there are states where there are a disproportionate number of women having to do things that undermine their dignity and quality. And if Casey was meant to protect those things, but to exercise the abortion right, you're undermining those things, then we say, hey, that's an undue burden. You don't have to just eliminate abortion. If you get an abortion at the end of the day, but you feel like less of a person and you feel bad about yourself, and you have to sacrifice things that mean so much to you, then that's not a right, even if you got the procedure at the end of the day. So that's our stance. And so I think there's a value in taking it to this court and taking it squarely to Kennedy. Yeah.
You mentioned that there were 2 clinics after the stay that were shut down or remained open. I couldn't quite catch.
Yeah, so I'm sorry, it gets confusing, right? So like stay, vacate, stay. Basically, after we won at the district court level and that judgment was stayed, when the Supreme Court stepped in, it allowed the ASC requirement to continue to be enjoined, right? ASC requirement, no. For the admitting privileges requirement, it said that it could go into effect except as to the clinics that were most brutally affected. And so that was McAllen and El Paso. And so both of those areas, again, are maybe have just like the largest numbers of low-income women, have, because of other legislative actions in Texas, including pulling the plug on contraception access in some ways, has seen just like declining health outcomes. And so I think that's what went into that decision. But we've argued that that's not enough and we need access throughout the state.
And was that decision based sort of like on like the standards for getting an injunction, like having to show immediate injury, or were they just picking and choosing like these ones are going to be way worse off to get?
I mean, so the standards for vacating a stay aren't the same as the standards for enjoining the law in the first place, but that is the only reason we could think of, and the only reason that makes sense in this sort of litigation, right? Like, but that said, it's still curious, right? I mean, even if you were going to use that standard, we'd argue that other areas fall into that, or so to some extent. And because that sort of decision isn't a decision like you see in a merits case, right? Like the decision was a couple lines long. We don't know what they were thinking. It could have just been that justices disagreed, and this was a compromise position that would like make everyone happy for now. Yeah, whoever.
So something that would be a concern for me if I was in your shoes as far as looking at what this standard might be that the Supreme Court's going to come out with. I'm thinking of Brown v. Ford. The Supreme Court came out with a standard. They said you're going to have to integrate these schools. It's not like the states that are enacting these restrictions are using like scientifically corroborated evidence
Mhm.
So, given that that's not what's coming out of these legislatures, is there a concern for you as to exactly what the standard could look like and how the states could actually be forced to comply with it versus just, prolonging the let's prevent people from getting their constitutionally mandated rights by making it look slightly different, exactly the same as it was?
Yeah, no, that's a great question. And I think the distinction lies in I don't think we can influence legislative behavior. I don't think that behavior is going to change. I do think a loss would sort of, make everyone feel like, hey, like we can do whatever we want. But in terms of our actions and the arguments we're making to the court, what we're really doing is trying to get district courts to require certain things of states, right? And so the idea is, yes, they're not, that's our argument, right? They're not basing these decisions on science, even when they're saying that they're scientific decisions and that they're meant to promote medicine, which can be measured in a lot of ways, right? And so that's our argument. They're not doing that. Force them to do that. And if they can do that, and again, that outweighs the burdens, then we lose. But if they can't do that, then that restriction isn't constitutional. So it's really sort of an argument for what district courts are, one, well equipped to do and have done in the past and should be doing to keep, I guess, just like the fundamentalness of the constitutional right, the abortion right. Does that make sense?
Yeah, it does. It's just, such a hard problem to solve.
Yeah, and I think your point's well taken in the sense of like, do I think Texas is going to be like, oh, okay? No, they're going to keep passing these laws. But the difference is going to be that, when it gets to the Fifth Circuit, inevitably, even if we have a district court judge who applied the sort of analysis that our district court judge did in this case, they're not going to be able to strike it down in the same way because then we'll have a standard. And if there's no evidence, then the restriction can't pass constitutional muster. That's an excellent question. So the first thing I will say is, unfortunately, it's not, I don't know how much of a wash it would be for us because the Fifth Circuit happens to contain some of the states that have been hardest hit by restrictions, right? So if you have that rule in the Fifth Circuit, then our other state where we're litigating in Louisiana suffers, right? And Louisiana is particularly interesting because the day after oral argument, we basically filed another petition asking the Supreme Court to vacate a stay that a Fifth Circuit had imposed on a district court judgment in Louisiana over admitting So the same thing basically panned out in Louisiana that had in Texas. And so I guess my point is that it actually, I don't think we would think of it as a wash because having that rule in the Fifth Circuit, so many of the women who are hardest hit and so many of our clinics and doctors who are hardest hit are in that circuit. So that rule in that circuit is really bad for us in terms of our clients' interests. And sorry, what was the second part of your question? Yes. Yeah, so my understanding is that the court can do what it wants, which is normally true with the Supreme Court, right? Like obviously, but my understanding is that there's no like default rule even, right? So it would be up to them. And given how many times they've intervened when they absolutely didn't need to, because all of these, you see the legal language, like all of these requests are extraordinary relief and only in the direst of circumstances, right? So the fact that they intervened, I think if they were going to say remand it or basically put it off in a 4-4 fashion and maybe like wait for us to relitigate when there's a ninth justice, I don't think that they would lift the stay. But it's totally up to them, so.
Undue burden also, except the kind of Fifth Circuit undue burden where it's like absolute, you're not balancing it, or were there other arguments that they were trying to make?
Yeah, so the Texas Solicitor General, who is an excellent advocate and did a wonderful job for his side, I think his arguments were twofold. So one was really like, look, states are owed deference. We hear this obviously, right? Like legislative enactments are owed deference. Courts shouldn't be coming in and telling legislatures what to do. And our answer to that would be sure. But when you have a fundamental right, you have more caution. Courts can be more involved, blah, blah. So I think that was one thing, right? Like states need to be respected. And especially with the purpose arguments we're making, which I didn't go into as much depth in, this idea that Texas meant to eliminate abortion, their argument all along, and I think you'll see this in the Wisconsin case that's coming up to the court, is that's disrespectful. And you're accusing states of doing these evil things, and that's not good, not only because it's not true in this instance, but because it creates a certain reputation around states and legislatures in the future. I think that was one of his arguments. And I think going along with that, it's, well, yes, because of that, because you have to trust legislatures, you shouldn't subject them to the sort of scrutiny that we're arguing they should, right? All that evidence and measuring it and having a sort of full-on trial in the way that we did. So I think that was his core argument. I don't think, he talked as much about burden, and I think that's tough. I mean, the Texas law really is distinct in like how many clinics it's closed, so that's been a little tough. But certainly the justices, and I'll say specifically the female justices, really honed in on, why did Texas do this? Right? Because again, and it's hard. It's a hard argument he's making. Like, it's okay. Well, we should be allowed to do this. You should give us deference. And okay. But why did they do it? Right? And so that was. And I think Justice Kagan in particular. Like, I think that was her question at one point when he was saying that. She was like, "But why would Texas do that?" Right? And like, so I think it's a tough argument to make because it has a certain limit always. And so I think that was a little tough for him. And also it was just. For me, it was like beautiful in a sense, but also a little troubling that it was like only the women justices in Breyer. And so, right, it's the progressive justices, but now that there's 3 women and they happen to be progressive, it was like that was the question they kept asking. But to me, they're not just talking to the Solicitor General of Texas, they're talking to Kennedy, and it gives me hope that maybe Kennedy is malleable on that question, right, as to how far legislatures can go and whether they have to present evidence for their restrictions.
So, my understanding of the abortion jurisprudence is that it's sort of like capped off its own undue burden test.
Yeah.
If that's somewhat true, is the goal in getting a standard to like further define what undue burden is, or to get a better sense of where the undue burden test fits within 14th Amendment law?
Yeah, I mean, so I think there's probably a little disagreement as to how special undue burden standard is in abortion jurisprudence as compared to other uses of like the undue burden language. And again, I think it's just kind of an open question because so many courts have interpreted it so differently. And so this is our standard that we're proposing. That said, I do think that we've really thought about it only in terms of abortion access. And that's really tied to Casey, right? Like Casey is just rife with that balancing language. Balance, 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 but respect, right? Balance, 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 but you can't like tell a woman what to do. You can like suggest, and you should have a voice, and you should persuade, but you can't tell her. So I would say, like, to be honest, it's very much cabin to abortion. And to your point, I mean, I don't know if that's good or bad, but I think it's right now like the first step that we need to take.
I have another one.
Yeah.
You mentioned a case coming out of Wisconsin. Can you give us a preview? What's happening?
Yeah, so I mean, I always feel odd about doing that just because I'm not on the case, and so I don't want to misrepresent their arguments. I paid more attention to the cert petition that the state of Wisconsin filed. So just to give you a little background, Wisconsin involves an admitting privileges requirement very similar to the one in Texas. And the district court applied basically the test that we proposed in our Whole Women's Health papers and found that the requirement was unconstitutional. And that's not surprising because admitting privileges requirements do tend to be pretty similar, whereas ASC requirements might differ a little bit. And then the Seventh Circuit reviewed it, and then also, why is everyone laughing?
I think we have a guest. And will join me in welcoming.
Hi!
Thank you for inviting me. I'm not going to interrupt, so I'm going to let Rupali finish, and then maybe I can join the Q&A. But it's really lovely to finally be here.
We're just on question and answer, so. But yeah, so the admitting privileges in Wisconsin, that requirement is very similar. And like I said, I'm more familiar with the cert petition that Wisconsin filed asking the court to review it. But it gets a little bit into the purpose arguments we were talking about before and how it besmirches the legislature for courts to really probe into that. You guys should really ask Stephanie some questions now.
So I know we only have a few minutes left, but can you just tell us briefly about your experience arguing whole women's health before the Supreme Court, just to hear your personal perspective?
Sure. It was a very intense experience. It was my first time arguing at the Supreme Court, and I wasn't quite sure what to expect. I knew it would be a little bit different than at the Courts of Appeals. And then Justice Scalia passed away just a couple of weeks before, and that kind of threw a wrench into the works. But it was a very hot bench. I'm sure Rupali told you that the justices, they were very well prepared that day. They all knew the record inside and out, and other than Justice Thomas, they all had a lot of questions to ask. And so my argument, I had divided argument with the U.S. Solicitor General. So each side normally gets 30 minutes. I split my 30 minutes with Don Verrilli, so I had 20 minutes and he had 10 minutes. Andrew probably might have told you that in addition to the main issue in the case, which is the interpretation of the Undue Burdens standard, there are also a bunch of sort of collateral issues about evidentiary matters and about res judicata. And I spent almost my whole first 15 minutes arguing about res judicata and sort of nitpicky evidentiary points. And then my red light came on. It's like, oh, I've got to reserve my rebuttal. I need my 5 minutes for rebuttal. So I was trying to thank you, Your Honor. I see that my time is running out. You know, and I went to sit down, and then Justice Ginsburg types in, excuse me. Oh, well, Justice Ginsburg, I better come back. I bet this is going to be a good one. And she actually said, excuse me, Mr. Chief Justice, we've taken up almost all of her time on these preliminary things. Could she please have some more time to address the merits? And it was amazing. It's like the greatest thing that ever happened to me. And then the Chief Justice said yes. And so, so I had a little more time to address the merits. And then, you know, it turns out that at that point, the Chief Justice just totally lost control of the clock. And the justices had a lot to say. They were very engaged. They had a lot of questions. So the argument, which was supposed to go an hour, went almost 90 minutes. Because they were so engaged, and there was this very, you know, there was definitely a very good colloquy about the medical evidence in the case and sort of the lack of medical justification for the laws that were being challenged. And I think that was probably the thing about the argument that sort of made me the happiest, is that medical evidence really penetrated, and I think what left me feeling the most optimistic afterwards is that you know, the justices, and I think pretty uniformly got that these laws aren't medically justified, and so if they adopt a standard where that matters, then these laws can't stand. The only way that these laws could be upheld is if the court decides to adopt a standard where the justification just doesn't matter at all.
I think we have time for, one more quick question.
I was just wondering how you prepared for it. Did you moot the arguments, or like what was it like to prepare for it?
Yes, we mooted a lot. We did many moot courts. And it was actually really great. I mean, we had recruited sort of a panel of Supreme Court experts, you know, lawyers that are practicing at the court all the time, and it included several former U.S. Solicitor Generals, so like really heavy hitters who were just very interested in this issue, and you know, and wanted to help make sure that the argument was well prepared. So I did a ton of moot courts in New York, and D.C., and Boston, and I also tried to listen to all of the arguments from like the last 3 terms, just to get a sense of this particular court, like what is their cadence like? What is the questioning style of all the justices? Because I'm based in New York, so I go and watch arguments in the Supreme Court occasionally, but I wouldn't say often. Maybe like once or twice a year. And so Rupali knows I was listening to Supreme Court arguments all the time. I just had them on my phone and like at the grocery store, at the subway, at the gym. I was always listening to Supreme Court arguments. I started to worry that like on the actual day, because I so often would listen to them on the elliptical machine, that I was going to start retiring. But I didn't.
Well, if you'll join me in thanking both Stephanie and Rupali for being with us today.